keeps me from my winter hell. I've got candles and candy, I can be your daddy if you only let me creep into your prison cell. Hey baby, can you tell I'm not a criminal? Your choice is seminal. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true. Just speak low, stand in your row, try not to show this life's a show. Try not to glow way down below. Oh, it's a lot of woe, and that's not a place where you would like to go. I've got cigarettes and brandy, which could come in handy if you just help me loosen up my hand grenades fuse. Baby, don't refuse my truth, but it's up to you not to choose. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true, 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 true.
Good morning, everyone. How are you? I hope everybody is having a fantastic day. We've almost made it to the weekend. It's going to be Easter weekend. Tomorrow is Good Friday. So, all you good Catholics, fasting, no meat. All right. So, today is the day that we've all been waiting for. We're going to listen to the closing arguments. We're going to get the verdict and listen to the judge explain why he adjudicated her the way that he did, why the verdict was. Okay, we're also going to listen to a little bit of the interview that Turtle Boy did with Kelsey and her attorney, Mr. Bradle. And then we're going to listen to a little bit of audio from Microdot's video. Both of these Turtle Boys Live and Microdot's video are linked in the description so that you can go and check them out in full. And I would encourage everyone to do so. I watched Turtle Boy's interview this morning, and I thought he did a good job and asked some really good questions. And so, yeah, we're going to do that. So let me say good morning to you guys, and then we'll get started. Good morning, Neat Noodle. Good morning, Preschool Granny. Good morning, Chicken Lady. It's also Jen's fault. The live wasn't posted yet when I went outside. It's always my fault. Just blame Jen. Blame Bindi. She did it. And I hear that we're going to, Mabel is getting close, or Maybell is getting close. Yay, maybe babies. Hey, Chief, good to see ya. What's up? Morning, everyone. Are we ready to get started? All right, let's go. Let me share the screen because I've got like 11 billion tabs pulled up. This one. Today we will be going with law and crime. I hope their audio was a little better because there is no closed captions. You guys know how I feel about that. I love the closed captions. I require them. I need them. I want them to be. But alas, they are not. So we'll have to do the best we can do. All right. Oh, let me speed this up a little bit. We definitely don't need to hear. Let's go to 1.3. All right. All right, you guys, let's get started.
Hear ye, hear ye, hear ye. All persons have anything to do before the Honorable Jeff Carter, Justice of the Superior Court, now sitting in orders before the County of Essex. You are here, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts, and this is the Honorable Court. Court is now open. Please be seated. Good morning.
Good morning. March 26, 2026, Court 2, Lawrence, Superior Court. Calling the criminal matter of Call versus Kelsey Fitzsimmons, 2025, 77 CR 311. Scheduled today for continued jury waive trial. Could counsel will please identify themselves for them.
Good morning, Your Honor.
Good morning.
Good morning, Your Honor. Martha Copley for the defendant, Kelsey Fitzsimmons.
Good morning. Good morning, Mr. Fitzsimmons.
Good morning, Your Honor.
Good morning, Your Honor. Timothy Bradle. With me is Ms. Healy. Ms. Tassin, Mr. Leonard. Good morning.
Good morning. Good morning. Thanks. You can have a seat. All right, so you folks ready to proceed?
Yes, sir.
All right, I don't say this for the attorneys who know this, but because the government prosecution has the burden, they go last. The defense goes first in their closing. And Ms. Bradle, you may proceed.
Thank you very much, Your Honor.
Good morning, I'm sorry.
Counsel.
Good morning, Jonah's mom and Jonah. Good morning, everyone who's joining us in the chat and those who are just watching and not chatting. Good morning to you too. All right, here we go. Also, pay very close attention to these closing arguments. Pay attention to the style, if you will.
Ladies and gentlemen, Your Honor, June 30th, 2025 was the worst day in Kelsey Fitzsimmons' life. Her whole world imploded. Her fiance betrayed her. Her baby was being taken away. She was going to lose her house, her job. It was an incredible confluence of tragedy that was visited upon her that day. That day was about her, and she decided in the midst of what you saw testified to here, she decided to end her life. Patrick Noonan.
Yes, Jonah's mom, the defense is going first in Massachusetts. The way that this judge has decided to do it is because the state has the burden of proof. They go last.
When we came back up those stairs, Your Honor, walked into a suicide in progress. That gun was nowhere near him. That gun was already pointed at Ms. Fitzsimmons' temple by Ms. Fitzsimmons. She was a couple steps into the room. Officer Noonan, a gung-ho cop, highly trained, a SWAT guy, he'd already been ginned up all afternoon by the insane, ludicrous statements of Justin Elaine. He had that in his head. He walked in, and like all of us are susceptible to, he made a mistake. He shot too quick. He reacted too quickly. And instantly, he realized that he had to adjust the narrative. And that was easy, to just add 6 words to the equation, Your Honor. He said, words to the effect, she pointed the gun at me. 6 words. What did those words do at that time period? Those words made him the victim. Those words made him the hero, And those words, most important, made him untouchable. Those words were a defense for his future, his life, his reputation, and they were conveyed to a very willing audience. His colleagues, his brothers, his family, the investigators on the case. So that's really what happened here, Your Honor, and it is a tragedy, and it is something that should not result in any further harm to Ms. Fitzsimmons. This should be over. This should be an acquittal, Your Honor. I want to talk to you about a few of the elements that I know you're going to be concerned about. So, first thing I want to talk about, Judge, is the lack of motive and the lack of intent. Because when it gets down to brass tacks, I know that you're going to look at the law, you're going to look at the credibility determinations, and you're going to make a judgment. And here, this case fails. The Commonwealth ship founders on the rocks of lack of motive and lack of intent. Let's talk about motive. Everything in life is motive. And it's ironic that, us lawyers always say, well, you don't need to prove motive. But you really kind of do. It's not be an element of the crime, but motive is everything in this business, Your Honor. Let's look at motive or lack of motive. Fitzsimmons and Noonan are colleagues. They have already bonded over shared tragedies, shared experiences. They were okay with each other. They were friends. Kelsey thought well of him, and she thought well of her. She knows he has a family. She knows who his family is. She's not going to harm this guy. She knows, Your Honor, that he didn't do this to her. She knows that Justin Eleni did this to her. And she's, probably most important, she's been in those shoes before, serving restraining orders. She knows she's just a messenger. She knows he's just a messenger. This was the worst moment of her life, and she wanted to end her life. And how did she want to do it? She wanted to do it alone. She didn't want to involve these officers because she knew this was a selfish act. She came in here, and ironically, the most credible evidence that came into this case, Your Honor, was from the one person that didn't have to testify. And she came in here and she chose to testify. She waived her rights and she testified. And she showed, Your Honor, that she's a moral person. She's a caring person. You'll sit down and you'll deliberate, and you'll be drawing the inevitable conclusion that Kelsey Fitzsimmons is a moral person. You have to contrast that with the callous treatment of this case from the other side. Hey, we're going to go serve an order on Kelsey Fitzsimmons. Her ex-fiancé got an order on her, on Kelsey. Let's go serve an order. The answer, sounds good. Let's go. Talks to his neighbor. Oh yeah, I'm the shooter. I'm the shooter. She's a whack job. So you have to take these credibility determinations into account. And I know you're a gentleman, but you have to get down to brass tacks on who's who here. What else shows you that she's a moral person? She doesn't want to involve these guys. She's trying to get rid of them. She says, oh, the guns are over here, so she can go where they really are. She keeps trying to give Houston and Noonan baby things to bring downstairs. She's trying to get rid of them. She's trying to get them away from her. She wants to do this on her own. She doesn't want to have some sort of situation where she gets shot by one of her colleagues and friends. It's understandable because she's a moral person. She waits for her chance. She gets to her room. There's a distraction downstairs. She doesn't know what's going on because she's focused on the job she's trying to do here. The tragic, awful thing that she's trying to do to herself. That's how you know she's telling the truth, Your Honor. You saw in the room, and I'll show it to you in a minute, the chest that she got the gun from, it's a chest on the floor. It has one of those pretty substantial lids that you have to flip up to get the gun, locate the gun, pick the gun out of the 4 guns, and stand up. If Noonan was standing right there in the door frame, that would have never happened. All those events, that little series of events, he would have been able to stop it. He would have stopped it. It tells you that he's down the steps. He was interested in the distraction downstairs. He saw Kelsey folding some baby clothes, getting baby things ready. His attention, it's human nature. His attention was drawn to go back down the stairs. He walked down the stairs 2 or 3 steps, 4 steps, whatever. And Kelsey told you, straight up, that was my chance. And she took it. And she went in the chest, Exhibit 51, Your Honor, I'll show you right now. She went in that chest, flipped up that lid, got the gun, stood up. She told you again, she's a moral person. She tried to keep the gun concealed. She made the motion like this, Your Honor, where she put the gun like this and she kind of walked over here. But she didn't want the police to see her with the gun. She held the gun to her stomach area. She walked to a clear area and she put the gun to her head. And that's what I mean when I say Officer Noonan came back up the stairs, and what did he walk into? He didn't walk into some Rambo woman trying to shoot him in the face. He walked into Kelsey, who you now know a little bit from her testimony. He walked into Kelsey's room, and Kelsey had a gun to her head. And he walked into a suicide in progress room. And the man that had just been holding her baby, that she chose to hold her baby, that she chose to feed her baby, walked into her suicide in progress. The gun was nowhere near Noonan. There was no threat to Noonan. And the law says that an officer may not use deadly force on someone who is exhibiting a danger only to themselves. And that's offered to Your Honor twofold, in the sense that it shows that this was not a reasonable use of force, and it shows you that his knowledge of that statute, as he said on the stand, gives him a motive to lie. He knows that this is not a good shooting. He knows this is not a clean shooting. And that gives him a motive here, Your Honor. And like all of us, we all make mistakes. He overreacted and he shot. He had the look on his face, panicked, flustered, he shot. He had made a mistake by leaving her there, walked down the steps, a few steps, and that gave her the chance. And when he did this, he knew immediately, Your Honor, that he had to adjust the narrative. Filtered through the legal lens, Your Honor, that tells us that Kelsey had no intent. She had no intent to harm him. There's no assault here because she didn't have the intent to do so. As the fact finder, you can consider everything you said about motive, that she lacked any motive to harm this gentleman. In fact, it was the opposite. She thought well of him. She knew Justin did this to her. She had just trusted him with a baby, and she had tried several times to get these officers away from the situation. No intent to harm him, no motive driving her mindset to do so. Reasonable doubt, burden of proof, Your Honor. Where the evidence supports a reasonable and more plausible alternative, and that's shown here by Kelsey's testimony, it cannot be said that Collins has proven the case beyond a reasonable doubt. There is reasonable doubt. When there are two plausible versions of what happened, that itself is reasonable doubt. The versions themselves, Your Honor, show reasonable doubt. Kelsey's version rings true. Noonan's version is all over the place. Noonan's version is contradicted by the strong consensus of everybody else in the house. Noonan portrays a couple different stories, but if you want to pick one where it's this drawn-out potential gun battle, where she's backpedaling, sidestepping, tapping, racking, there's commands going on, that takes time. It takes time for me even to say it. Never mind do it. And that's belied by everything everybody else in the house says. Everyone else says, Kelsey no, 2 shots in quick succession, bam. That does not fit with what Noonan said happened. So, on that alone, Your Honor, as a fact finder, I suggest that your duty is accomplished quickly, because there are two extremely divergent versions of this event. And Noonan's version has changed itself. Noonan's version is inconsistent with who you now know Kelsey is as a person. It's self-serving. And like I said, it makes him untouchable. And when you judge it against everyone in the house, he's the only one with the Rambo story. Everyone else has what Kelsey says. He walks into a suicide in progress, he sees it, he reacts, Kelsey no, bam. Brain freeze, mistake. Has to cover it up immediately. What else do we have? You know, when you're a fact finder, you want to look for corroboration. What's the corroboration on either side of this thing? Or lack of corroboration, which is what really it is here. You know, the big one, the big elephant in the room is that this department has no body cameras. We wouldn't even be here if they had body cameras. There's no evidence other than people's words. He said versus she said. That's oftentimes, almost all the time, not a good place to start for the Commonwealth. How many of these guys didn't do reports? What's up with that? Why didn't Trooper Strong put the body camera video on the witness he's interviewing? There's no science. The testimony of everyone else in the house shatters his narrative. Kelsey Fitzsimmons has been blessed. She should be dead 2 times over. By her own hand and by the hand of Officer Noonan, who shot her. She's blessed. She's here today, and she has a new lease on life. Maybe that's why the investigation is what it is. And maybe that's why the story is so sloppy, because nobody expected her to be here today and tell her truth. But she is your honor. And as the fact finder, I want to respectfully ask you to consider the evidence, consider the lack of motive, the lack of intent, the inconsistencies, the credibility contest is firmly in her camp. She came in here and she told you what happened. Unvarnished truth. And I ask you to find her not guilty. Thank you, Your Honor.
Thank you, Mr. Ritter.
Okay. Basically, short, sweet, to the point. No emotional plea. No name calling. None of that. Just address the court, address the fact finder in this case, which is the judge. Short, sweet, to the point. He's not wrong. If you really sit and compare the 2 testimonies, which are the testimonies that matter the most, really, in my opinion, because they're the 2 people that were there. And he's not wrong when he says we wouldn't even be here if it wasn't for the fact that the police department doesn't have body cams. He's also right. I said this yesterday. I think that Noonan did not expect for her to survive. And that's why his story is not a good one. You know, I agree. Let me look. Neat. Let me look. I'm not buffering on my end like when I went back and watched on the phone. So there's me again. Yay, 2 times Jen. Yuck. All right, so let's keep going. I'm not buffering, but I am echoing. All right, here we go.
I mean,
Yes.
every piece of credible evidence in this case proves one thing, that she's guilty. All the testimony, the scientific evidence, the physical evidence, the demonstrative evidence, everything points to one conclusion: she is guilty. Even her own testimony proves she's guilty. Because it's impossible to have happened the way she said it. It is scientifically, mechanically impossible for it to happen the way she said it. Her story is that she grabbed a gun, put it to her head, pulled the trigger, and it clicked. The chamber was empty. That's what her story is. And that's what Officer Noonan's story is, too. She pulled the trigger, clicked, nothing came out. There wasn't a round in the chamber. She even said she told everybody how stupid I am. I tried to kill myself with an empty gun. But what do we know about the guns? What do we know about her gun? Because after she went to the floor, Lieutenant David picked it up, put it on the bed. Officer Noonan picked it up and put it on the table. And then Officer Core came in the room. And what happened then? Officer Noonan said, secure that gun, make it safe. And so what did he do? He took the gun, he found that black box, the safe. He made sure that was empty, he turned it over. He pulled out the magazine that you can see right here. He opened the chamber, and there was a round in the chamber. He dumped it out into this safe and put the firearm in it. And then they stood watching that until State Trooper Bonasaur took it back in the lab. That magazine that you have in evidence contains 16 rounds. It was a 17-round capacity gun. It contained 16 rounds, plus the one that was in the chamber. 17 rounds. As we know, there are only two ways to get a bullet into the chamber. One is if there's already a bullet in the chamber. Someone pulls the trigger. A bullet comes out, the casing comes out, the chamber's open, the spring allows another bullet to come out. That's one way, and we know that didn't happen here. The gun didn't fire because the chamber was empty. The only way a bullet gets in this chamber, other than that way, is if someone racks the gun. She said she didn't rack the gun, but there was a bullet in the chamber. She did rack the gun. What did Officer Noonan say? She pulled the trigger. Nothing happened. She stepped back, tap racked, tried again, didn't do it. Tap racked again, pulled it, and that's when he fired. She put a round in that chamber. That's the only way it got there. Her story can't be true. She got up on that stand and she lied to you. It's scientifically and physically impossible for her story to have happened the way she said. That's what the evidence shows. But she didn't just lie to you then. She lied again. She lied at the scene about where the guns were. And she admitted that, and I understand that, right? And she said she lied to the police because she decided to kill herself. But when did she say she said that? They had been to the house. They had talked to her, according to her. She now started contemplating all of the ramifications of what's going to happen to her. Because she's losing her life, her job, her son is being taken away, all of these things. And so she's going that over her head. And then minutes later, as she's walking through the house, she says, my gun's in the basement. Because that's the time she made the decision to kill herself. Later on. And we know that's a lie. We know that's a lie because what was one of the first things they asked her when they went to that house? They asked her to put the baby down, because they were concerned with the baby, told her the restraining order, what the parameters were, and asked her where your guns are. When she was still sitting on the sofa. They weren't waiting to ask that question so she was already walking around the house. No way. And what did she say there? They're in the basement. And we know she said it there before she moved around the house, which is untrue. Because her friend, Officer Houston, who was invited to her wedding, says it also. He says, Sergeant Daly asked. And then remember what he said? He said, I was in the living room, she was sitting down, and then I saw a gun case on the other sofa, and so I opened it up to see. And she said again, I already told you the guns are in the basement. Now, why at that point did she say that? We don't know. She didn't tell us, because she lied to us about why she said it later, because we know she didn't say it later. So she lied again. You can't trust her. She also lied about knowing that her mom was in the house. She was upstairs. The officer, Noonan, I think it was, Noonan heard an older woman's voice down there and said, who is that? She says, I have no idea. She doesn't know her own mother's voice, her best friend that she just talked to come to the house. And she said she didn't know whose voice it was. Another lie. She said on the stand yesterday that she didn't know Justin was in the house. And we know that's a lie too, because what happened when the three of them were upstairs? It's Noonan, it's Houston, and it's the defendant. She hears him downstairs. Houston hears him downstairs, and she says, keep him away from me. I don't want him in my house, or something to that effect. And that's when Houston went down to make sure he wasn't coming up and went to the basement. She knew he was in the house. She absolutely did, and she lied to you when she said she didn't yesterday. And you know what else she lied about? Something so simple, but it shows who she is. The restraining order. She said, the restraining order was taking my dog away. It says it. It doesn't say that. Nothing about the dog in there. I could go on about the lies, but I want to talk about the credible evidence. The credible evidence in this case. When Lieutenant Daly got a call, actually got a visit from Justin O'Lane when he was in the lobby of the PD. And Justin told him he got into a 9A against Kelsey Fitzsimmons. And Detective Daly knew that she had been second before, that she had guns, that they were taking the child away from her for a period of time. And so what did he do? He called Officer Houston. He asked Houston to call Daly to meet up. And why did he say he did that? He said because those two are cool, calm, and collected. They don't panic. They keep things calm. That's what he said. And that's why when he called Houston, he said, can you call Daly, we gotta do this. And so he wants you to believe, defense counsel, that Absent was cavalier about, oh, okay, sounds good, we have to serve a restraining order. But that's not what happened. He was mischaracterizing it, and I hope you remember, in the grand jury minutes, because Houston had called Pat and said, hey, we got to serve an order, can you meet me by the school? Pat said, sounds good. It wasn't until he got over there, it wasn't until Lieutenant Daly was there, that they learned really what they were going to do. And they went over there. And defense counsel asked Daly, you guys were cavalier about it, you knew her, weren't worried about the guns, all this stuff. And Lieutenant Daly said, no. No. His quote was, we had an increased level of vigilance. Everyone was more on point because they did know what they were walking into. They did know. They did know that she had been sectioned before. They did know there was going to be a baby in the house. They did know that she had guns. They did know at that point that she had parked her car far away. This is all going to what they were thinking at that point. They did know all those things. And they did know Justin's concerns. He said, according to Lieutenant Daly, I'm worried she's going to kill the baby, kill herself, and kill someone else. So that's what they were thinking when they went into this house. That's the credible evidence when they went in there. And what did they do when they went in there? They sat her down, and they allowed her, or maybe they asked her, I can't remember, to go around and get some stuff for the baby because she knew Justin was coming to get the baby. And they were in her pocket the whole time. They followed her around the house, at least two of them, while she did that. And you know that because even Officer Houston said, I was in her pocket. We went into the kitchen, and I noticed there were butcher blocks with knives on it, with knives in it. And they were concerned. There was no chance they were leaving her alone. No chance they were leaving her alone. Officer Noonan. Officer Noonan. All of the testimony that you've heard about Officer Noonan, even from the defendant, he's a gentleman, he's experienced, he is by the book in his training and experience, starting in the military, through boot camp, through security forces school, security forces squadron, with all the training he had, and Humvees and helicopters, and the SWAT team, 2 times a month training, clearing rooms, clearing buildings, hostage situations, missing persons, shoot, no-shoot scenarios, twice a month, and a 40-hour block every year. For over a decade he did that. And he moved to Lawrence, as far as the department goes, because it was busier, and he had more experience. He was cool, calm, and collected. There's no doubt about that. And to say, when they're upstairs, and he walks away and leaves her alone because he heard a commotion that Officer Houston was going to attend to, is a joke. It really is. Now, how do you know they were going by the book at that point? And how do you know they were diligent? Because they followed around everywhere. Because both Houston and Officer Newman said she kept handing us things, and we kept putting them down. We wanted our hands free. Because they were ready for whatever happened. Hoping that they did, but ready for whatever happened. So at some point, Houston and Newman are upstairs, and the defendant goes into her room. And she hears Justin. And Houston goes down to keep the peace to make sure he's there. And Officer Newman is watching her. He's watching her. And she's on one knee. And she lunges, and she disappears. And she emerges with this, pointing at him like she is trained to do. Click at his face. And what does he see next? He draws his weapon, and he says, this testimony, it kind of slowed down. The whole thing took maybe 4 seconds, maybe even 3.5 seconds. His training has kicked in. His experience has kicked in. It was a surprise to him, certainly, because she got the drop on him. And why did she do this? Who knows? Maybe he's right. Maybe she was going through him to get to Justin. Maybe she was just so upset she was going to shoot anybody in front of her. Maybe she wanted him to shoot her. We don't know because she lied about it. We don't know. But the fact is, she started to shake, she started to tremble, and she lunged for the gun that he couldn't see. And what happened after she flipped? She stepped back, and now he knows, based on his training experience and the clip, there is not a round in the chamber. He knows that, and so he doesn't shoot. According to the defense testimony, he had every right to shoot at that point. And you know what? He actually did. He had a right to shoot her at that point. If you point a gun at a cop and pull the trigger, they get to shoot. But he didn't. Because he was controlled and disciplined. That's the way his career went. And so she steps back, tap, crack, and tries to do it. He doesn't shoot her then. And what's he doing at this point? Kelsey, no. Kelsey, no. Because he knows the threat isn't there, really, because there still wasn't one in the chamber. Kelsey, no. Kelsey, no. He is being disciplined like we wish every police officer, every law enforcement agent in this country was. He should be applauded for his actions on that day. Tap rack again. Now he knows one's in the chamber. Threat's on. She starts to raise it, and he shoots. He shoots twice to stop the threat. He stopped shooting when the threat was neutralized. Defense counsel, during his cross-examination, well, you would unload it or not. He goes, no, that's not what you do. You shoot until the threat is neutralized. She was now down on the ground. But his training and experience are still taking over at this point, because what does he do? He still has his gun on her, because the gun's still there. He can't see it. Lieutenant Daly comes in, Lieutenant Houston comes up, and what does Officer Houston say that he sees when he comes upstairs? That Officer Newman is standing there with the gun low and ready. His training is still taking place. He's still doing what he was trained to do. The gun is put on the bed. He's calm and collected. He takes the gun and moves it away so people are safe. He's deliberate in those actions. When it's away from her, he starts to tend to her. Officer Core comes in, and he orders, well, he asks Officer Core to make the gun safe. He's cool, calm, and collected. That's what Lieutenant Daly expected, and that's what he was. He didn't make a mistake. That's what the credible evidence shows. And what did he say to Officer Houston after it? And this just goes to state of mind, I know. That she pointed the gun at me, and it clicked. And she tried to rack him up. Immediately after, this wasn't him saving his hide or protecting himself. Seconds after this happened, that's what he said. Every piece of credible evidence points to the inescapable fact that she is guilty. Every piece of physical evidence, scientific evidence, mechanical evidence, every piece of testimony from Daly to Houston to Core, even Lauren Page, the mother, even the defendant corroborates what Officer Newman says. Every piece. Your Honor, I would suggest to you there is only one fair and just verdict in this case. that is guilty. Thank you.
Moving to a sidebar.
I'd like to speak to counsel anyway inside our scheduling service.
All right.
Is that Mr. Ruane, our assistant clerk, will keep possession of the ammunition and the firearm will come. She testified. So
Hold on.
use of deadly force is not before me. That is not my decision.
I agree with you. It's just that when you act out
Hold on. I don't know what this argument is about, but it's very impassioned.
on
Go-
Noonan's story, I believe it was to ballistic, saying that Kelsey
Not sure how we got here. Let's just see what's going on here.
Will be switched out. All right. Okay. Globally, have I discussed what?
Jonah's mom says, was Noonan even investigated at all? Well, I don't know about Noonan being investigated personally, but whenever there's an officer involved shooting, there's always an investigation, an internal investigation. So you can take that for what it's worth. I feel like I don't think it was a good internal investigation. I don't think it was a thorough internal investigation because there's a lot of it. There's inconsistencies in his story, number one. Okay. But I think the most important part of his testimony is all the things that he said that she did in such a short amount of time, but B, space. Where she was backing up, there was no real room for her to back up. He has her backing up in between a bed and two walls, a wall behind her and the wall to the side of her, as if that's going to give her a better angle. I mean, it makes no sense. I mean, what he said happened didn't really happen. It couldn't have happened the way he said it happened. Look, I said it yesterday. I think that when he realized when he came back up those stairs, however many that he went down, I mean, it's not like a huge stairway to begin with, right? As far as it's narrow. I don't even know how they got that furniture up there, if I'm being honest. That is some Tetris level furniture placement if I've ever seen it, which I appreciate. But I think what happened is I think that Kelsey knew she needed to be alone. She needed to get them out of the room. Do I think that she was telling the truth when she said she didn't recognize that voice? No, I don't think she was telling the truth. I think she did recognize that voice, but I think she knew that if she said she didn't, then they would have to go down and investigate it. And they did. And then Noonan realizes, fuck, I left her unattended and alone. By the way, nobody is even looking for the firearms. They take her word for it that they're down in the basement. Okay. And so, and what he yelled out is his testimony about what he yelled out is contradicted by what other people who were on the scene's testimony is. He wasn't yelling the entire time. I agree, Nate. I think he probably was fond of Kelsey. You know, when two people go through something that's real messed up, trauma bonding, that is a thing. And I think she looked up to him. I think that I think they had a good rapport. I do. And I think this guy did, and it's really sad for me to say this, it doesn't justify anything, it doesn't excuse anything. I think he freaking, once he realized what he had done, I think he panicked. And I think he lied, because if it wasn't a good shooting, a just legal shooting, he's going to lose everything. And likely, if she had not have survived, he would have lost his freedom as well for a longer period of time. That's what I think happened. I think he was covering his ass. I actually don't think he thought of Kelsey in that moment, one way or the other. I think he thought only of himself. I think he had a Cartman moment, panicked, and lied his face off. That's what I think. All right, so let's see this argument.
I said in open court what we discussed. Okay, all right, so Mr. Bradel, I'll hear you on the objections.
Thank you, Your Honor. So, Judge, traditionally we do this at sidebar, but as you mentioned, we don't have a fact finder here that we need to talk off to the side to. So, in open court, I'm happy to do this. Sure. Yep, I'll go back over everything I said at sidebar, Your Honor. Judge, the first objections I have to counsel's closing argument center on ballistics issues. The first part is that counsel picked up the gun and used it 3 times. Prior to that, counsel provided what I would consider to be expert testimony on the operation of the gun. I think it exceeded the scope of what Detective Bonasaro talked about. He said that it had to be a scientific certainty that this gun was racked by Kelsey Fitzsimmons. Mischaracterizes the defense position that we're not saying necessarily that it did or didn't happen. We said that Kelsey Fitzsimmons didn't rack the firearm. And we have a completely different version of events. So no one's saying that it didn't happen. We're saying that Kelsey didn't do it. And to characterize it like, you know, that it had to be racked by Kelsey Fitzsimmons is not fair argument, and it mischaracterizes the state of the evidence. The second objection relative to ballistics, Your Honor, is that counsel was acting out. I believe it was the second time he picked up the firearm. Counsel was acting out on Noonan's story that Ms. Fitzsimmons had accessed the firearm from the chest and picked it up to point it at Noonan's face. And on Noonan's testimony, she just pulled the trigger and it clicked. Counsel's acting it out. Prior to pulling the trigger, counsel racked the firearm and then pulled the trigger. And that's not what happened on even Noonan's testimony.
I'm happy to allow you to make a record, but the fact that there's 2 different versions of what folks testified about is fair game. What the issue right now is whether the Commonwealth argued items that were not in evidence or attempted to draw inferences from items that were not in evidence. So the disagreement about the racking is just not before me.
Well, that's why I bring it up, though, Judge, because this racking issue has been brought up to the forefront, and he did something that is not part of the evidence. No one says that she racked the gun before the first shot, and that's what he did when he acted it out. So that's why it's a mischaracterization. I'll just rely on Your Honor's discretion.
But that's not what Mr. Gubitosi did, though.
I did see him rack the firearm before he fired the second shot. He did it the second time, Your Honor.
Okay, I'm having trouble understanding. Again,
it's just that when you act out the testimony, you have to do it accurately, and he didn't.
I'm going to say this in open court, and it won't be the last time I say it. Whether or not Officer Noonan exercised reasonable use of deadly force is not before me. That is not my decision.
I agree with you, and I say it on credibility.
And hold on. And whether the North Andover Police Department followed procedure in executing, serving this restraining order is not before me. Child custody is not before me. All right? Visitation is not before me. What's before me is, has the Commonwealth proved beyond a reasonable doubt that the defendant pointed that firearm for any perceptible amount of time at Officer Noonan? Okay, so all of this is just not helpful.
And I offer it on credibility, though, Your Honor.
Okay.
Also, the Commonwealth said that on the scene, Ms. Fitzsimmons didn't say part of her story there, so therefore she's making it up. And whenever the Commonwealth tries to argue that a defendant, didn't say something, that's very dangerous ground for the Commonwealth, Your Honor, that the defendant is under no burden whatsoever to say anything, Your Honor. And here, to suggest that she's lying because she didn't say part of her story when she's shot in the chest at the scene is unfair argument, but it also violates her right to remain silent. And it's an intrusion on that, so I would object to that. I ask you not to consider that, Your Honor.
Except that, Mr. Bradel, she waived her right to remain silent, right?
I was
She
just gonna
testified.
say.
So
At the scene, though,
Isn't it fair game for the Commonwealth to discuss the testimony that your client offered?
The testimony, yes, but he's saying that at the scene, she didn't say XYZ when she didn't have to say XYZ at the scene. And that's, the Commonwealth can only argue that when a defendant makes a comprehensive statement and leaves something out of it. You can't say that especially in her condition, that she didn't say something and therefore she's a liar. She has a right to not say anything. So that's my point on that, Judge. And then the last two more issues, Judge, is that there was a mischaracterization of the evidence where counsel stated that Justin Elaine told the officers in the lobby of the police station that Kelsey will kill someone else. He added that to the statement that you might recall, that he said he wouldn't be surprised if she didn't kill the baby right in front of them. That was the statement. He added in that she would kill someone else, which in this case is a very dangerous mischaracterization, that he's ascribing an intent to my client that she wanted to kill someone else, which didn't happen. That was not the statement. So that's a very important, very dangerous, very unfair, very prejudicial misrepresentation of what was attributed to Justin Elaine in the lobby. She never said anything about killing someone else. He didn't even he didn't say that she said that. So I ask you to strike that and not consider it. And the last thing, Judge, about lying about the dog on the restraining order, Your Honor, that trying to take her dog. And it is in the complaint to the restraining order by Justin Elaine.
Why are you objecting, State? Because, I mean, we can go and look at that, and we will look at that. The complaint is in Microdot's video, and we're going to look at it, because this is going to come up in the interview as well.
I know you're trying to do a second closing, but the evidence is what the evidence is.
Yeah, but Judge, you can't say, when you have the discovery on the point, you can't say that something is a lie when you have the papers that show it's not a lie. And the box was checked in the complaint to get her dog. So that's a mischaracterization of the evidence that needs to be corrected, Your Honor. And that's my last point. Thank you.
So, Commonwealth, from my perspective, with all due respect to Mr. Bradel, who's done a terrific job advocating for his client, I view that as nothing more than a rebuttal to the Commonwealth's closing. So I'll give you a few minutes to rebut these things. Let me say this, though. I don't believe that there was any evidence before me that Miss Fitzsimmons was sectioned previously. I think that the way I view the evidence is that this is what the police believed. It was part of their state of mind in serving it. But I'm at a loss, frankly, that, in other words, what I'm saying, Mr. Bradel, is out of all the items that you argued about the Commonwealth purportedly arguing something not in evidence,
Yes,
this sectioning, alleged sectioning that happened prior to this,
Yes.
there's no evidence of that before me. There's mention of it, and it goes to the officer's state of mind. So, and that's all that, in fairness, that's all that you argued, Mr. Gubitosi. But I guess what I was getting at is if there was anything at all that came close, that would have been it. But Mr. Gubitosi, I'll give you a few minutes for your rebuttal to the rebuttal.
I don't think I trust you to have sifted through what's relevant, what's not relevant. The evidence is what the evidence is. Closings are not evidence. I would suggest to you that, I guess I do need to be heard, I guess.
I mean, closing is not evidence.
That I argue the evidence that came from the witness stand and from the exhibits to Rubanasaro absolutely describe the ways that a firearm works and how a round gets into the chamber, and I limited my explanation of that to what he described and the like. I don't need to make a second close. Thank you.
You just did that.
I'm a lawyer. What do you think about that?
I respect that, both sides. All right, so at this point, why don't we, I said that I was going to step off for the gathering of the evidence. Let me not do that. I'd like the counsel to just make sure that all the evidence, the exhibits are
All right, let's just skip forward.
And on both sides. If you folks can take a look at the verdict form as well. I don't know if you already have. It's not complicated, but you want, Mr. Bale, have you seen the verdict form?
All right, are you guys ready for the verdict?
This has been one of the more.
All right, here we go. Now we're going to get to the verdict. I'll say this. The difference that I noticed in the closing arguments is that the defense spoke to the fact finder in this case, which is the judge. It's my opinion that the state used an emotional appeal, which would work better in front of a jury. So to me, it seemed like their closing was aimed more at a jury and less at a judge. I'm not a fan of using emotional pleas in that you're calling. I don't like the way he did it. I don't like the way he used it. I mean, there is an element of an emotional plea when there is a victim, right? And in this situation, Kelsey, in my estimation, is the victim. She's the one that was shot, but the way that the state perceives it, Noonan is the victim. So there should be a level of emotion there, but I think that when the facts are on your side, that's what you should lead with. Lead with facts. Reserve the emotion for speaking of the victim, but not using emotion to, Kelsey's a liar. She's a liar, pants on fire. Like, I just didn't think it was a good closing argument. So, all right, let's see the verdict. Let's hear what he says.
Good afternoon. We're on the record on the Kelsey Fitzsimmons matter, docket 2025-77 CR 311. All counsel and the defendant are present.
Thank you. So,
Hold on. Let me, because I want to clean that up. Thank you, Jonah's mom. Name calling. I don't like that to me that has no place in a closing argument. To call her a liar. It's different to say she lied when she said X, Y, and Z. She was untruthful when she said A, B, and C. That's different than calling somebody a liar. I know it's arguing semantics, because if you lie, what are you? You are a liar, right? But I just think in a courtroom, and first of all, that's what all lawyers do. They argue semantics. They argue the interpretation of the law. That's just how it goes. That's what they're there for. But I do think that there is no place for that type of argument, name calling, in a closing argument in a court of law. I just think it's lowbrow, and I don't care for it. All right, here we go. Now we're going to hear it for real.
Again, I'd like to speak to our audience members. I understand that this case has generated a lot of passion and emotion, but you must remember that this is a courtroom and not a sports arena. When I announce my verdict, you must not act out emotionally or visibly or audibly react. So you should leave the courtroom if you believe that you will be unable to maintain your composure. I'd like to start with a few introductory words. Let me say this is not in my script. This has been one of the more exhausting, hardest things I've had to do as a judge, as an attorney. So as the lawyers know, unlike when a judge presides over a jury-waived trial in a civil case, there is no requirement that a judge explain their reasons for reaching a verdict after a criminal bench trial. I do so in this case because I think that Ms. Fitzsimmons, Officer Noonan, and all the people involved in the tragic events of June 30, 2025 deserve an explanation. Next, I'd like to take the opportunity to publicly thank and commend the attorneys in this case. They all did an exceptional job presenting the evidence and conducting themselves in an extremely professional and civil manner. And they did so under the public spotlight in an emotionally charged case. I commend you. To the extent that any of the prosecutors and attorneys may be vilified or subjected to public scorn for simply doing their jobs. In this case, I say that any such scorn is unfair, unwarranted, and simply wrong. These prosecutors and attorneys fought hard but performed their solemn jobs fairly with the utmost civility and professionalism. They serve as a shining example of our adversarial system in operation. Now, I'd like to publicly acknowledge the crucial and often thankless role that police officers perform, a role that Ms. Fitzsimmons herself, like Officer Noonan, willingly and selflessly performed for the citizens of North Andover. For this, you should be thanked, not disparaged. For those that think that serving as a police officer is easy, or that officers don't care or take pride in their work, I say with more than 3 decades of experience in the criminal justice system that you are naive, misinformed, and sadly mistaken. The work of police officers is especially fraught with peril today because of our exceedingly cynical, polarized atmosphere, where our citizenry often believes that there is a conspiracy under or around every corner. I saw no evidence of a conspiracy in this case. What I saw was dedicated public servants like Officer Noonan and his fellow officers doing the best they could under tragic, rapidly evolving promotional circumstances. What I also saw was a young woman, Ms. Fitzsimmons, who was also a dedicated public servant, react to sudden, confusing, and heartbreaking news. Now let me turn to the evidence and the law. Our system of justice requires me to decide this case solely on the law and the evidence. So the only things I have considered in reaching my verdict are the 98 exhibits admitted during the trial and the testimony of the 11 witnesses that testified here in open court. While it may be cold and uncaring, our system of justice demands that emotion, sympathy, and concern for the consequences of my decision play no role in my decision. As for the law, in order to prove Ms. Fitzsimmons guilty of the crime of assault by means of a dangerous weapon, the Commonwealth must prove the following 3 things. We lawyers call these things elements beyond a reasonable doubt. First, that Ms. Simmons committed an assault on Officer Noonan. Second, that Ms. Simmons intended to commit the assault. And third, that the assault was committed by means of a dangerous weapon. The sole issue before me is whether the Commonwealth proved each of these 3 elements beyond a reasonable doubt. And more specifically, under the circumstances of this case, the narrow issue before me is whether the Commonwealth proved beyond a reasonable doubt that Ms. Fitzsimmons pointed a firearm at Officer Noonan for any perceptible amount of time. What is not before me are the legality of the issuance of the restraining order to Mr. Alain, the reasonableness of the procedure used by the police to serve the restraining order, the legality of Officer Noonan's use of force, and issues regarding the custody of Katie. It is not my place to decide these issues or even mention my thoughts on them. I am thankful for this because my role has been hard enough. What has made my job especially difficult in this case is that by and large, I found the testimony of Officer Noonan and Ms. Fitzsimmons to be credible on the material and relevant points. In my experience, this is unusual and somewhat perplexing. On the one hand, Ms. Fitzsimmons credibly testified that she never pointed a firearm at Officer Noonan. On the other hand, Officer Noonan testified that not only did Ms. Fitzsimmons point a gun at him, that she also pulled the trigger. Both agree that it happened in seconds near a narrow doorway, and the crime scene photos show that the door frame was made narrower by a clothes rack containing police uniforms that was to Officer Noonan's left. The door frame was also made, the door frame was made still narrower when Officer Noonan used it to take cover when he drew his firearm. During the closing argument, the Commonwealth argued that it is scientifically and physically impossible for Ms. Fitzsimmons' story to be true because there was a bullet in the chamber, and she said that Officer Noonan shot her without her ever wrapping the slide after pulling the trigger. I disagree that the evidence reflected that the only way to chamber a round would have been to pull the slide under those circumstances. However, even if I assume that Ms. Fitzsimmons lied about not wrapping the slide, it does not detract from the adamancy and credibility of her testimony that she never pointed the gun at Officer Noonan, about which he was equally as adamant that she did. Perhaps the Commonwealth could have easily met its burden if the officers had been wearing body cameras. But under these circumstances, I am left with a reasonable doubt, and I am duty-bound to find that the Commonwealth has not met its burden to prove that Ms. Fitzsimmons committed an assault by means of a dangerous weapon on Officer Noonan, and my verdict is, and must be, not guilty. With that, I will hand the signed verdict slip. I will hand the signed verdict slip to Mr. Wayne and ask that he advise Ms. Fitzsimmons of her statutory rights.
Ms. Fitzsimmons, could you please stand? On docket 2025, 77 CR 311, count 001, the court having returned a verdict of not guilty, the court orders that you be discharged of this indictment and this indictment only, and go thereof without delay. Kelsey Fitzsimmons, as required by statute, I must inform you that the records regarding the charges for which you have been found not guilty will be sealed by the Commissioner of Probation and by the court unless you notify the Commissioner of Probation in writing within 10 days that you do not want those records sealed. To request that those records not be sealed, you may use the request not to seal form posted on the trial court's webpage on mass.gov, or a copy of which I will hand to your counsel. I cannot accept the form here in court. You must submit it to the Commissioner of Probation at the address provided on the form. You understand?
Yes, I do.
Thank you.
Thank you. Court is in recess. Good, all right.
Please exit quietly.
All right, so there's the verdict. She was acquitted, which I think the judge. Okay, so there's two types. Okay, let me just try this again. In my estimation, there is not guilty, right, which is an acquittal, and then there is innocent, and they're two very different things. In my estimation, based on the evidence, I think that Kelsey Fitzsimmons is actually innocent. That's very different than simply an acquittal. It's very different than simply saying I had reasonable doubt, or the jury saying there was reasonable doubt. Therefore, we had to find her not guilty. I think that Kelsey Fitzsimmons is actually innocent. I know that I suppose the judge could have said that in his reasoning and his explanation for the verdict, that he found her to be factually, actually innocent. He didn't say that, which I thought was interesting. I don't know how you can listen to both Noonan's testimony and Kelsey's testimony and find that they were both credible. I'll say this, under the law though, if he found Kelsey credible, that is in and of itself reasonable doubt, and therefore he must find her not guilty. But I do think it bears saying that I believe that she is factually and actually innocent. Okay. So, which should we do first? I'm going to leave it up to you guys. Should we listen to her interview, or should we listen to a little bit of Microdots? Which do you guys want to do? Microdots has multiple audio. One of them is Justin and Kelsey the weekend of Mother's Day. Then there's another one there's a couple of phone calls with officers. He has the actual, there is the actual, what is that? The complaint, the request for the restraining order. You guys want to do Microdots? All right. That's what we'll do. Okay, give me just 1 second. Let me move this here. Let me share this tab instead and make it bigger. Turn on closed captions. All right. So the first audio that we're going to hear from Microdots video, which again is in the description, I will put it right now in the chat if you want to save it for later. The first audio we're going to listen to is from, excuse me, a recording where you can hear both Justin and Kelsey. It is Mother's Day weekend. All right. So let me show you guys this and play it.
Devolved into verbal abuse.
You are such a fucking terrible person. All I came up here to do is to fucking be with you and maybe fucking have any indication of fucking kissing it. Nope.
Kissing me?
You are
You
such a
came up
bad
here
person.
to yell at me.
Came up here to yell at you. You're fucking terrible. You're yell at you?
Thank you. You did come up here to yell at me. That's
No.
exactly what you came here to do.
Sure. Can you put the light on, please, so I can get the fuck out of here?
You fell over in the bathtub. You fell over up the stairs, and you're embarrassed. And I called you out on it because I just want you to go to bed and wake up in the morning and go to your training. But all you want to do is insult me. So thank you. That's like super fucking nice. I'm sitting here rocking our baby, and you say,
Kelsey,
"Oh,
shut the fuck up."
okay." Still have our little baby in my arms.
Yep.
But
no,
okay.
You're right. That was the first time of me yelling, but only the 10th or 12th time of you doing that.
No, this is not the first time of you.
Can you please put the light on? Because
yelling.
I am out of here. I'm not doing this. I'm leaving.
Look. Okay, bye. Let me just say this. If you need help putting a light on, you probably shouldn't be driving and going anywhere. That's just my opinion. Let's keep going.
Please put the light on that you just had.
You're leaving after I just got you to maybe lay down and be able to go to your training.
Good for you.
Like, not be drunk and go to your training. You'll what? Like, I don't understand.
Can you put this on, please?
What on, dude? Like, what is going on? It's the middle of the night. You're fucking freaking out. I don't get this. I do not get this at all. You fell in the shower, you slammed your head. You fell in the living room, you slammed your head. You came up here, you started freaking the fuck out, saying you're all done, you want to go home. Like, what are you doing?
Well, to me, Kelsey, he sounds like he's drunker than Cooter Brown. He can't even figure out how to work a light bulb, a light switch. I mean, it's not like this is, he's got to wire shit together to be able to turn on a light, for the love of Pete. He's not trying to invent electricity. I mean, this dude sounds like a piece of shit. I'm sorry, he does. Like, look, I can understand. I know people get drunk, and I know some people get drunk and they get belligerent. Okay. I don't have patience for those people, but I also don't have patience for people who are drunk and belligerent and think it's a good idea to drive. I don't have patience for people who are drunk and belligerent and are, hollering. His voice is definitely raised. He has a tone in front of a new baby. Like, I just think he just doesn't sound like a good dude,
Like, seriously, what are you doing? What is the point in all of this? What are you doing?
Thank you very much, Kelsey. You have said a lot, and you have been very, very helpful.
I've said little to nothing. All I've said is I want you to lay down and go to bed so you can go to your training in the morning and not have an issue.
You know what? You are fucking brutal.
Okay. I'm fucking brutal because I want you to lay down, go to bed, relax, go to your training in the morning, and be normal.
Yep.
Right?
Sure. Absolutely.
Yeah. See, this is why it's a shame that everything happened in the way that it did, because clearly Kelsey would have made an excellent police officer. She's trying to de-escalate the situation. She can't not, I feel like recognizes that she's in an impossible situation here, right? She could have ignored him, which I think actually would have escalated things. I think that she's talking as even keeled and calmly as she possibly can under the circumstances. Also, she's holding the baby. I mean, bless his little heart. We can hear him burp. Poor little thing. And I think this is very indicative of a person who's trying to de-escalate a situation. Unlike Miss Miracle, Dr. Miracle, who is screaming, I've got a gun too. This is how you de-escalate a situation.
Okay.
Absolutely.
I don't know if like you're like pretending to agree with me or
Yep. No, absolutely.
please don't fall down the stairs. Oh my god. Oh, okay. Jesus Christ. I'm so fucking nervous right now. I'm so fucking nervous right now.
All right. And I'll tell you another thing. And this is really smart on Kelsey's behalf. Ladies, gentlemen, if you find yourself in a situation like this, in a relationship like this, obviously you need to, the ideal circumstances is that you would just leave. But I know that realistically leaving is difficult for many reasons. Emotionally, financially, also if you're in an abusive relationship, it's the most dangerous time to leave. And if you can't leave right away for whatever reason, for at least document. Please document. Okay, so now the main trip gets talked about, and I'm going to save that for you guys to listen to. I don't want to play that for you, but this is another bit of audio.
Text messages, lots of them, saying she needs him and
Please call me right now. I'm being so serious. I need to talk to you, please. And your son, you will call me right now. If you care at all about me and your son, you will call me right now. I'm being so serious. I need to talk to you, please. Please come home to us. It's not normal to run away from problems like this, making them worse. Come home to your son and your wife. We don't need to talk about anything, but I can't handle doing this alone. Please come home to Caden. Please come home to your son. He needs you, Justin. I have work tomorrow. We need you. Take your time and come home before you get to bed. The police just came to my house, ?
that was the moment she noticed a cruiser pull in.
Okay, so I'm going to let you guys watch that on Microdots to get the full backstory of that. There was an accusation made of a hit and run, but Microdots goes into it more in depth, and I'm going to leave it there. One of the things that's interesting to me is that one of the claims that Justin made was that Kelsey was a danger to herself and to their child. Yet here he is reading those text messages out, and in no way she has future plans. She writes in those text messages, I have work tomorrow. And the explanation is that there's a lot of text messages. So I would imagine that those are not all of the text messages. But just based on that, and honestly, that's kind of all I need to hear. The fact that she has future plans is indicative of somebody that's not intending to harm themselves. Or not intending to harm themselves or somebody else in that moment, which is what he used to go and get the restraining order. after the restraining order was gotten, and she learned that her son was on the restraining order and that she wasn't going to be seeing him, that, I mean, look, a restraining order is no joke. It is a big deal. And she was going to lose her firearm. She likely would have, I don't know if she would have lost her job forever, but she definitely would have been suspended from her job pending the outcome of the restraining order hearing. So to say that she was going to harm herself and that is why he went and got the restraining order is preposterous. I think when it all came down, yeah, I definitely believe she was like, well, you know, I think she had a moment. I do. A moment she now regrets. All right, so we're going to skip through this. Here, we're going to get to the audio here.
Had also left because they
Interview why Kelsey was investigated for being involved in an accident.
on the way home, two of her friends, Cassie and Deandra, had also left because they never wanted to talk to her again. On the way home on the highway, they got into a hit and run. Someone had hit them and taken off. They believed that it was little Willie's car, just based off of the black car. They thought it was a Cadillac, and they truly thought Kelsey was in the state of mind and had the ability to take that wheel and swing it over and hit them. So they thought
they were in a separate car.
They were in a separate car, and they, looking at Kelsey's location after that, they're like, we think Kelsey might have actually just tried to run us off the road.
This baseless accusation from two of Kelsey's brothers.
Yeah, that's ridiculous. Okay, so let's keep going.
At that very same moment, Justin was making a phone call.
Hey, this is Justin again. I'm just calling Lieutenant Whitaker back. I just missed his call, unfortunately.
Yeah, Justin, it's me.
Oh, okay. How you doing, sir? I had a couple quick questions for you again.
Yeah.
So she's messaging me, telling me that she's planning on taking the baby up to the land in New Hampshire. Do I have any rights to make sure that she does not leave with that child?
At this point, I don't think we do. I've spoken to my superior.
Yeah.
Filled him in on everything that we talked about, and we don't really have the right to deny her child.
Do I have any rights as the father to obtain my child since she's had him for several nights now? Do I?
No, you don't. There has to be a custody agreement, and this is what. Oh, this is irritating to me. I mean, let me just keep going because this part just. I mean, it's going all over me. Do I have any rights? Do I have any rights? She's had him for several nights now.
Have any right to? Hey, this is a custody. We're both parents here. It's almost my turn to have the kid for the night, so I can know that he's safe and I can go file these after.
I can have the kid for the
department.
night. So I can have the kid for the night. That's how you talk about your son. That's how you talk about your child. Get bent.
But no, we don't have that ability. The only way that you would be able to do that if you spoke directly to her and said, you know, I'd like some time with the baby. And if she agrees to that, great. But it sounds like she's probably not going to be. Yeah.
I mean, why would she? Why would she? You know, there was an argument at the bridal shower, the joint bridal shower, at the joint bachelorette party. Okay. He was intoxicated. Spoiler alert, he hid shrooms in her stuff. Okay. She was pissed, and rightly so. She's a freaking officer. Those are illicit drugs. She could have lost her job and gotten caught criminal charges for the love of Pete. Okay. I wouldn't leave a baby with him either. I wouldn't leave a fucking pet rock with his ass. I don't blame her. And besides the fact that here you are, there was a lack of communication. I remember Kelsey's testimony, and there was a lack of he wasn't he wasn't speaking to her. Then all of a sudden he's speaking to her. Then he's not speaking to her again and ghosts her. And then she's ambushed with a freaking restraining order. I mean, is that about the sum of it? Hey, Daria. Hey, Amber. Hey, ATS News. Good to see everybody. Coffee and skeletons. And it is. Look, here's the truth. When it comes to something like this, when there is no custody agreement through the courts, okay? There's no recognized custody arrangement. Unfortunately, and this is how it works, whoever has the baby at that, or the child in that moment, has all the power. That's how it works. That's the way it is. If the shoe were on the other foot and Justin had the baby, he would be able to take the baby anywhere he wanted to. And there wouldn't be a damn thing that Kelsey could do about it in that moment. She'd have to go through the courts. It's that in that regard, it is a level playing field. Whoever has possession of the child, whoever the child is with in that moment, is the one calling the shots. That's just how it goes if there's no custody arrangement. Okay. But he just, it is harder for fathers. Courts, although I think courts have changed in recent years, but courts do typically favor the mother. You have to prove that she's unfit. All right.
Sister, who's
Hey
had a
there.
quick question for you as well.
I'd saw.
Here comes the sister. What is that, your fucking representative, bro? Like, you're a grown man. You need gas money from your mama, and now your sister's got to ask questions. Why couldn't she ask you the question and you put it on speakerphone and she can hear it? Why is she involved in this at all, other than to be supportive of her brother? Like, nosy busybody.
I've seen a lot of this, and so I'm on the page of we need to get the baby out of her hands like now, or something really bad could happen. And I know you guys have talked a bit about this, but I am just wondering, is there any difference if she were to try to take the baby out of the state? Does that go against anything? Because that's what she's threatening with. Does the state matter at all? The state lines?
No. It really doesn't. It's her child.
It doesn't. Okay.
Yeah.
One other question for you, because I think, we're talking about going to the courthouse. How do we, and especially because she is a police officer in this town and everyone talks, and I'm just wondering, if we go file this, how do we, because if she finds out that this is filed before it's being addressed, it's going to end really horribly. So how do we actually ensure, and I guess, do you know anything about that process? Would a police officer come with us or with Justin to the house to get the baby? If this is assuming the custody was ordered, that the restraining order and the custody were ordered, what does that look like? Because we're very worried she'd find out before it could actually take place.
Yeah, so if that's the case, then the way, if an order is granted, they will then email a copy of the order to us for service. So we would serve it and then enforce it. So it would be like, here's your restraining order. Per the order, custody of the child is awarded to Justin, in which case we would have to make arrangements, for him to come take the child.
Okay, so he would not be there when you're presenting that. I mean, this might be an obvious question, I guess, because if he has the restraining order, he shouldn't be there.
Sorry, I clicked the wrong button. Let me share it again. My bad. It's like amateur hour over here. What the hell? I'm going to rewind back a couple of seconds. Let's go back this way. All right, here we go. Oh, I got to put it on the screen. Lord.
Case we would have to make arrangements, for him to come take the child.
Okay, so he would not be there when you're presenting that. I mean, this might be an obvious question, I guess, because if he has the restraining order, he shouldn't be there.
Probably not. I mean, we should probably take care of that. It's okay if he wants to be close by, in order to take custody of the child quickly.
Yeah, right.
He could come if he's in town. We could then reach out to him and say, okay, she's been served. You can come pick up the child now.
Okay.
Look at that. Everybody seems to know that once the restraining order, if the restraining order is granted and it is served, that Justin should not be there. Class, Where was Justin that day? There, where he should not have been.
One, just to, I guess, make sure that, because I know you guys will get notified if there is an emergency order put through. Like, I mean, she's an officer, of course. What does she have access to see? I'm just, like, is there a way to flag this directly to, you know, the trusted?
No, when it gets sent,
friend?
it gets sent to the officer in charge. So
Okay.
nobody sees that except the officer in
Okay.
charge and anyone else who has access to that email, which she does not.
Okay, so that's reassuring. So I'm just trying to make sure there's no chance she could find out before this happens.
Did she catch wind while she was at the police station of anything occurring? Like,
Nope.
no, okay.
Nope. I didn't want to tip her off and give her the opportunity to do anything rash.
Okay, thank you. All right, officer, I appreciate your time. Thank you.
Very good. Thank you.
Sure.
Bye.
Okay.
All right, so now we're going to look at the actual. Wait, there's more audio. What is this? Hold on. Let me see this.
Was that over the past few hours, the wheels were turning again.
I got 1:33. I went to the Lawrence District Court. I would want to say I got there around 2:33ish. At that point, I filled out the documentation for the 201.
So let me just say this, you little sneaky snake. You got over there and filled it out at 2:30 when you told Kelsey to meet you and your newborn son. 4 months old, is still a newborn, still young, still a little baby. At the park. You rat fink.
I went in front of the judge around 4:30ish, I want to say.
Okay.
That was granted. At that point, it was faxed over to the police station. I went to the police station with a copy. My sister was with me during that.
At 5:49, Lieutenant Daly, Officer Noonan, and Officer Houston arrived to serve Kelsey the restraining order. Statements threatening to harm both her.
All right, the part that I'm interested in, and I'm going to mute this, is the dog. All right, let me see. I'm guessing this is that's the order granting it. Okay, so let's keep going. This is a really, I don't want to watch too much with you guys because this is a really, really well done this is a really well done documentary. The editing is great. The audio, it's just well done. And I want you guys to see it. And I know how hard it is to put together a documentary. So this will be we're going to listen to this part and then we're going to go listen to Turtle Boy. Okay.
All right, I'm going to have it noted that
show up. To the extent that charges will come forward, they will fit what took place here.
Justin?
Yes.
Yeah, I'm told that the plan is if anybody does show up to give us a call, we'll be there immediately. We're very limited today on staff, but if there's any issue at all, we'll be there momentarily.
All right, I'm going to have it noted that if something does happen, I requested 2 times for a police officer to be there from the beginning. I want that noted because I will escalate this further because this is not right from given the situation that occurred in that house and the potential for something else to happen.
I'm sorry. Given what occurred in that house, where's Kelsey right now? At this time? She's in a hospital fighting for her life, you schmuck. And you're going to escalate the call. What a little worm.
My family should have never been in that position in the first place. Now I'm requesting something that is shit that should be placed there, and you're telling me no several times. That right there is not right.
Justin, it's Katie. We spoke yesterday.
We
You
did
asked
speak yesterday.
Huh?
We did speak yesterday. Given the intense nature of this situation and what could occur, I'm going to be there for 2 to 3 hours. I know what her father's capable of. I know what could happen.
But
Pressure media are there. I'm just telling you.
I understand the stressful situation, but what we spoke to yesterday was that we weren't going to prevent you from going in the house, but if something happened, you could call us right away and we'd be there. And that was what we spoke.
Okay. No, we did.
Yeah, Justin, but they don't work on your time. First of all, you're calling the popo for an escort, okay? They don't work on your time frame, bro. They work on, they can do it when they can do it. Okay? So let's start there. Second of all, didn't he already go over to the house and get his crap before? Isn't that what he said he was doing there on the day that the restraining order was served? How much more crap do you have there? Well, what is it that's so valuable that you are willing to, go over there unaccompanied by the police, risking a confrontation with the homeowner's father, who you say is dangerous and, all the things, right? Like, if this is your way, I'm sorry. And I know this is going to be mean and I know this is going to sound cruel, but I don't care. This is just facts. This is how I feel. All right. If this is how your line of thinking is, I don't know that you're in the best position to be raising that child. You should not be the sole influence on that child. Okay. Your thinking is messed up.
Speak about that, and after thinking about it again, I wanted to make my concerns noted 2 times. So if something does happen, if something does occur, this will be noted. And
why are you going someplace where you know that something potentially could happen or something could occur, but you want it noted 2 times? Why not fucking note it 3 times? Is it 3 the magic number? You might be too young for Schoolhouse Rock. I don't know. This is ridiculous. You entitled little twerp.
And I have no problem escalating it further. I appreciate your time. Thank you and have a good day.
What time are you heading over there?
I will be there at 9:30 with 5 or 6 other men. It's going to take a couple hours.
All right. Well, that's there was no formal request at a certain time, Justin. I understand.
I understand that. I went through Crystal as well. I asked Crystal. Crystal said she would ask as well. That never coming back to me. This is a formal request. I called yesterday. You gave me this information. I'm calling again this morning, and I'm telling you that. You guys do last-minute details every single day. This is a last-minute detail. Yesterday would have been a detail that was not last-minute.
Would you like it?
A last-minute detail. Who are you to be talking to anybody this way? You entitled little twerp. What is wrong with you? Do you think that you're needing to go get your crap takes precedence over actual crime and actual cop duties? Get bent. Hold on a minute. We need this. Where is it? Here we go.
What a bunch of a-holes.
Sorry.
Details?
I am not paying for a detail.
Okay, all right,
my family should have never been in that situation. My child and myself should have never happened. I will absolutely escalate whatever I have to do. If I'm saying that I don't feel comfortable and I don't want to put my brother again, my friends into a situation where something could occur, or if you knew what happened, I don't know what her family would be capable of at this point. They've already filed negligence against me as the father when there has been nothing. I don't know what they're going to do. I don't know what they would be capable of. But if you want to wait and find out, that is on you. And I am.
No, buddy, it's on you. You wait, and they'll do it when they get to it. Okay? I can't with him. It's so annoying. What are you?
Glad this is a recorded line.
Me too. Little asshole. All right. Let's see. What's this?
Know the alarms went off, and I have no doubt in my mind he's going to be driving down from New Hampshire to show up here.
Okay. Whereabouts from New Hampshire would he be coming from?
He's up in the not the Rochester. I forget exactly what town he's in. He's probably about 40 minutes away, 30 minutes away. I don't know if he's.
Justin is not wicked smart. How do you like them apples? I got a number.
Coming, but I have no doubt in my mind that man is going to come down with a vengeance.
Okay.
He's so fucking dramatic.
I mean, do you think that
I called? I called 2 times. My family should have never been in this position. I called 2 times, once yesterday, once today.
And this is.
And I'm
look. You moved in with her, right? Right. You didn't have. You couldn't do what was necessary to get a home or whatever. You couldn't buy a home jointly, whatever. You had to fucking get gas money from your mom. Shut up. They did. He said they filed negligence on him as a father. I guess I'm assuming that what he's talking about is something in custody court that they filed against him maybe on Kelsey's behalf. All right, so there is Microdots. Okay, please go watch that because I don't want to play I don't want to play all of his audio. I don't want to play I don't want to take away. You guys should all go and listen to that. Go watch it. Okay, now the next thing we're going to watch is the interview between Turtle Boy, Tim Bradel, and Kelsey Fitzsimmons. I'm going to turn on the closed captions. That's not what I want. Excuse me. I want the closed captions. Where's the button? There we go. All right. So hold on a minute. I think I want to start with this, which is where they talk about trial readiness. I thought that this was interesting, and I'm only gonna play a little bit of this, a few clips that I found to be interesting, because again, I want you guys to watch this for yourselves. A lot of I get it. I know what kind of work goes into stuff like this and coordinating and all of the things. So I don't want to take away from that, but there's just a couple of clips in here that I think are interesting that I want you guys to see. All right, let's see.
Tim knows about this. Tim, why don't you say what I would do?
Superstitious gal I've had.
Really? Okay. So she hired you. She didn't hire you, like, because she was in the hospital. She was like completely indisposed, and someone from your family hired him. Is that right? Why him?
Your dad. You met with your dad. Yeah, we met with your dad. Your dad, Steve, was kind of the catalyst of it, I think, from your guys' end.
Why Tim? Where'd they pick him from?
Yeah, what the hell?
Yeah, where'd he come from?
No idea.
So you never? It obviously wasn't your choice because you were undergoing surgery and stuff like that.
So you want to know what's weird is when I was in the hospital, I had no idea I needed an attorney because I just thought that I was like this suicidal person that had gone through so much, and I didn't know I was accused of a crime until my parents told me. And when they told me, it was like a complete shock. And they ended up.
And you didn't know what crime it was?
No, not until you told me.
It is crazy to think. I never thought about it that way. That, like, from your perspective, you were suicidal and got shot.
I mean, can you imagine that? Can you imagine that? So your boyfriend, the father of your child, breaks up with you via restraining order, which also includes your son. And not only does it include your son, but you're going to have to be without your son for at least 12 days until the court date. And then it's up in the air how that goes, right? So you are you're feeling hopeless in that moment. You try to, you hold a gun to your head. It misfires because there's not a chamber in the round, or there's not a round in the chamber. Jeez, Jen. And you get shot twice, hit once, right? Right? Isn't that it? Then you find out while you're fighting for your life, and by the way, you're keenly aware that in all of this, your son is still with the father, who is a snake, okay? And then you get told, oh, by the way, you've been charged. Fuck that. All right, here's where I want. That would be fucked up. All right.
Got a good one. And, you know, you guys rushed through this trial. I mean, there was 9 months ago, Tim. I was arrested 3 years ago, and we haven't even come close to a trial yet.
Time, dude.
But you said with her, there were different priorities, obviously. You wanted to get this over with.
Caden, number one priority, right, Kelsey?
Yeah.
We're getting there. It's
And
coming, honey.
you weren't
Coming
worried you weren't worried about rushing it like that. I mean, that's a lot. That's quick to go to trial. No?
Are you asking me?
I'm asking him because he's the guy, but like with you too, you know?
No-brainer. It was a no-brainer, Aiden. I mean, you know, we knew what happened, and you know, this was a trial all along. There was no, you know, pontificating about what we should do. And you know, we were in that ridiculous pickle of she gets reincarcerated. You know, we didn't trust the Essex trial Superior Court judge to do the right thing, so we had to go to a higher court, you know, and that took a while. And you know, they didn't give us all the discovery until, like, you know, the trial. And you know,
I want you guys to hear this, okay? This is so thrown off, unprofessional, and wrong on the part of the prosecution that they didn't even give them all of the discovery until at trial. So I'm going to rewind that so you can hear it because it's so important.
they didn't give us all the discovery until, like, you know, the trial. And you know, yeah, and Kelsey was loving this one. We got a report of Lieutenant Daly after he finished testifying, 4-page single-space report after he finished testifying. So you know, they weren't ready to go to trial early. They said they were, but they weren't. And yeah, so it was a lot of discovery, dribs and drabs. You know, we needed to be ready, but we were going to plow ahead anyway. You know, I knew what we had. I knew what was going to happen here. I knew she was going to be a great witness. I knew she was testifying all along. She wanted to tell her story, and you know, we had to just get this going. And we finally got that judge off the way they did it. But hey, we'll take it. We'll take the win any way we can get it. We got a really great judge. Judge Karp was so great. You know, a gentleman, a kind man. He really looked at her with, you know, like a human being. And we didn't have that up until then.
No, you didn't. And
that was insane.
Okay, so now he's going to talk about the closing, which I think is important, and then we're going to end it there. Once again, let me give you guys the let me put Turtle Boy's video in the chat, but it's also in the description. Okay, so I want you guys to go over there.
I never saw that before.
All right,
And as a prosecutor, I mean, you pick up the gun once, and that's it. He picked it. I mean, controversy by pulling the gun out, pulled it out 3 times. And the scientifically impossible stuff, like, he way overplayed his hand there, and he kind of did a jury close, okay? Because Gubitosi over.
All right, we're just gonna leave it there. I'm not rewinding with that anymore.
When he mentioned that,
I knew that was going to be okay, because Gubitosi overplayed his hand with the gun, and the scientifically impossible stuff, like, he way overplayed his hand there, and he kind of did a jury closing. You know, you have to do a judge closing. You have to turn the dial down a little bit, because judge.
You don't pull a gun out in court?
he pulled it out 3 times. There was an article in the New York Post just on his pulling the gun out, this little tiny article.
Yeah, I couldn't believe he did that either, but I didn't want to interrupt it. Daria, you're welcome, babe. I want to make sure that you guys go and watch it. I'm not a big channel. I mean, but sometimes people don't, like, they haven't had the opportunity, or they saw it and they forgot, and now they're over here listening. And I just want everybody to go and listen to it, because I actually thought that this was a really good interview. I know people feel how they feel about Turtle Boy, and feel how you want. It is what it is. I ain't trying to tell you how to feel. You know me. Feel how you feel. But I did think this was a good interview, and I thought it was important to share just parts of it. So that's what I'm going to do. All right, here we go.
And how he created this controversy by doing that 3 times. Like, I don't do that in like a double murder closing where you're, really need to turn up the heat. I would, as a prosecutor, I mean, I would, you pick up the gun once and that's it. He picked up the gun 3 times. That was insane. I never saw that before.
He's like a cowboy.
And he pointed it like straight ahead. What was that all about?
Yeah, it's just like, dude,
that was
not good gun safety. Not good. That was all bad. Bad.
Good.
He was really being theatrical. Like that, like you said, that's something you do for a jury. Like the judge
People
has
gave me crap for kind of dialing it down a little bit, but I know how you do a judge trial. That's how you do a judge trial. You keep it on the merits and you kind of underplay things a little bit.
See, I agree here. I've only watched, this will only be my second bench trial ever. The first one I watched was Henry Dinkins. And he was accused and found guilty of murdering his son's sister, half-sister, Breasia. And I thought that, the judge in that case was excellent, fair. But the fact of the matter is the evidence was against that guy. And I think that I think his defense attorney, essentially, this was going to be a very highly emotionally charged trial because it involved the murder of a little girl. And I think that he correctly waived his trial. He waived his right to a jury trial, which also, by the way, is going to spare, 12 and let's say 4 alternates, 16 people from having to look at those horrific crime scene photographs, So I think I think the correct decision for him was to waive a jury trial in lieu of a bench trial. I don't think he did it to spare anybody, but I do think that the reason he agreed to it and the reason it was suggested is because it would be an emotionally charged trial given the circumstances. And I think what they wanted was a judge who you really can't make under these circumstances in this type of a murder trial. You couldn't make an emotional appeal to. You have to appeal to the law and the evidence. And so it's on my channel, Neat. Wait, hold on. What's Tess saying? I think we'll hear an end result. There is a video, and I'll go get it for you guys and share it. I decided not to play it. Here's why. It is of a custody hearing from October of 2025. This is why I won't play it. And that's my choice, right? I'm not judging anybody for playing it. In fact, I'm glad that I got to watch it. I just think that leaving it on one channel is enough. I don't need to replay it over here because at the end of the day, it has to deal with the child, and the internet is forever. And eventually this child might grow up and decide, hey, let me search the tubes, and bing, bang, boom. I don't want to be a part of that. Okay. So, I'm going to share it in the chat. I'm not going to share it in the description where you can find it. And if you're in here now, great, you'll get it. If you're watching it on replay, you won't get it because I don't keep up the chat. Because I like people to be able to say what they want to say. And sometimes you can't do that, and you guys know how these streets are. All right, let's go.
Glad you brought that up. A lot of people did give me crap for your closing. It was, what do you say to them?
Well, I've done a few of these bench trials, and it's a different animal. You want to choke off the government's avenues and opportunities for making points. So you keep it very minimal. And you know a little bit about that. We've been in that position. And the judge asked us at sidebar, no character assassination, like he's calling her a liar, because of the thing about the dog. I mean, give me a break. He was way too over the top for that. That would have been fine for a jury, but you have to match
Can
the
I
audience.
just say that my dog was on the restraining order? Can I say that?
Yeah, so it was a little bit of just a miscommunication, Kels, where I guess it was in the application where he wanted the dog, but I guess it didn't make the papers that were admitted into court as the exhibit. So I think it was just a miscommunication. I don't think it was fair for him to call her a liar for that.
A liar.
Either way, it was the intent. He wanted you not to have the dog. That's messed up.
And my dog was in my house during that time. He was staying with my dad because we had gone away for the weekend and my dad hadn't brought him back yet. And they asked me where my dog was. And the intent was there. Let me just say that. The intent was there.
I'm not going to make any dog jokes. I was going to make a funny joke there. I will tell it when you're off the screen. I had the funniest joke there. I didn't say it because I'm being mature here for my lawyer. Okay.
She's got a great.
We all appreciate that, Turtle Boy. Follow your lawyer's advice and be mature. All right. So here's the custody hearing. I put it in the chat. I think that that's really all I wanted to show you guys. I think you should definitely go and watch it for yourself. I don't want to take away from his interview. I know like 11 billion people have, hey, Laura, what's up? What are you, and about? I think that, I thought it was a good interview. There is one little part that I was like, I don't know about all that. Basically, he asked Kelsey and Bradel if part of the reason they were treated the way they were treated through the court system was because of him. And he said, Bradel said no, which I agree with. Look, did Turtle Boy cause a kerfuffle up there in Massachusetts with the Karen Reed trial? He did. But the thing about causing that kerfuffle and causing that ruckus is he brought a lot of attention. He brought a lot of eyes. And I don't think they treated Kelsey or Attorney Bradel the way they did because of him. I think that they treated Bradel and Kelsey the way that they treated Bradel and Kelsey because this involved a cop on cop and somebody was going down. And which was it going to be? A 50-year-old man who, had all this experience and was part of the boys club, or was it going to be the rookie? That's what I think. You know what I'm saying? Like, I think that's why they treated her the way that they treated her, not because of, Turtle Boy, for the love of Pete. Like, bro, calm down. Chill your beans. Okay. All right. So that's really all I have for you guys. I'm going to get off of here. I have a lot to do. I have a lot of work to do. I need to finish some videos for you guys. I need to, I need to finish, I need to finish and start some videos. Well, see, so Daria says, I think it's a legit question. He did a lot with Kelsey's case too, but I also agree that it had nothing to do with his shenanigans. He talks about that a little bit more. Like he says, he kind of kept it on the low, initially, but, yeah, it would have been like a legitimate question if he didn't then follow it up by answering it himself. And then they answered. Like, I don't know. I guess it's a legitimate question, I suppose, but it's one that he thinks it is. It's because of him, partly because of him, and I just disagree. I don't have an issue with the question. It's just, yeah. Anyway, that's really all I have for you guys. I will have content out. I don't know if I'm going to be live Friday or not. I'm still waiting to hear about the Athena Strand murder trial in Texas. I hope that they show that in some capacity, whether it's on a delay or like at the end of the day. I don't know. I would like to see it. I think that it's an important case. I think that it should be shown, but it's also a difficult case, and it involves, once again, the death of a child, which is always heartbreaking and difficult. But I wish they would show it. There is a current trial going on right now in Hawaii, and that trial is of a husband who is charged with the attempted murder of his wife. She survived, but not for his lack of trying. I don't know if you guys want to get into that or not. It's fairly underway, and I'm nervous. It's been underway quite a while at this point, and I actually think we're getting to the closings. We'll see let's just take it one day at a time and see what's going on at the beginning of the week next week. Daria said, next witness did a video on Richens and had clips of people reading the text. I feel like you should have been part of that. Well, I mean, I appreciate that you guys appreciate my dramatic readings, but maybe not everybody likes my dramatic readings. I did see the voice challenge that I was tagged in. I did. I have never heard I've never heard them on a panel, or if I have, I've forgotten about it. And it's like, that data has been overwritten with lines from movies and song lyrics, just the way my brain works, and random crazy scary ass facts about serial killers. So I would be more than willing to accept any challenge like to that. Like I think it's a lighthearted thing, and I think the meant it lightheartedly. Like I think it's just I think he did testify, babe. I think he testified, yes, the Trouble in Paradise. That's when I was just talking about Chicken Lady. It's in Hawaii, and the husband is charged with the attempted murder. She survived, not for his lack of trying, murder of his wife. And I believe he testified yesterday, and I believe he testified that she was acting shady AF, but he ain't do it. So maybe we can get into that, like, if there's nothing going on trial wise, like Monday or something. I don't know if I'll be live Friday. I haven't decided yet, because I really want to get some videos out for you guys. And the fact of the matter is, after I sit and talk on a live for, a while, like the last thing I want to do is read, like at that point, because I can hear my own voice, right? So I don't like it. I know you guys like it or whatever, but when you're editing a video, then you also have to read it. Then you have to listen back to it, and so that's like a lot of hearing your own voice that just, quite frankly, I'm not that into. I'm not going to lie, but I owe you guys some videos, and I need to get those out. So, but yes, Daria, dear, the challenge accepted. There's my formal acceptance. I don't even know if I commented in it. I probably should leave a comment. All right, I'm going to let you guys go. I've not heard anything else on Rex Heuermann, but I'll definitely look. And if anything comes up between now and then, maybe I'll go live with it. I don't know. All right. You guys have a great rest of your Thursday. For the people that live in Penguin Land and are getting an ice warning on Easter weekend, stay bundled up, stay safe, stay warm. I'm thinking of you. Let me know if you guys need anything. All right. Hit me up in the emails or the DMs or the texts if you got it. All right. I'll talk to y'all later. Have a great rest of your day, and I'll see you all later. Bye.